Hey, everybody. Welcome to Thursday night. I am John Skiba. I am the host, the attorney of the Consumer Warrior YouTube channel. Like I said, I'm a licensed attorney in the state of Arizona, and each and every Thursday night we do this. We come on and talk about different debt-related things, how to win debt collection lawsuits, bankruptcy, credit reporting, fair debt collection, all that kind of stuff. So I appreciate everybody checking in tonight. Sorry I missed last week. I've kind of had a hectic schedule lately. But how we do this is if you have questions that you want to discuss and topics you want to discuss, if you're on the YouTube platform, go ahead and put them in the comments, and then I will throw them up on the screen and we will discuss them. I have to give my disclaimers because that's what attorneys do. We give disclaimers. My disclaimer is I'm only licensed in the state of Arizona, and nothing that I share today should be considered legal advice. We're talking on YouTube. And if you want legal advice, you need to find an attorney in your location who can help you out. I also have some tutorials that can help you in templates. I didn't put a link, but I will put a link in the chat there before the night is through. And you can, those can be of assistance as well. If you're in the state of Arizona, you can see my law firm. I work for the law firm of Jackson White. You can see the URL down at the bottom, as well as the phone number if I can be of help. So with all that being said, if there are questions, go ahead and throw them up there in the comment section, and we'll discuss them. Something I wanted to announce, I put this on the channel yesterday, just I did a poll. I've been kind of toying with the idea of putting together a boot camp. And I say that because one time I attended a continuing education boot camp when I was a younger attorney for fair debt collection cases. That was very helpful. And so I've been putting the framework together for a boot camp to help with people who are dealing with debt collection lawsuits, where it would be something like this, but it would be live, and it would be maybe like on a Saturday morning or some weekday evening, something like that. Probably be several hours to go through a lawsuit or how to defend lawsuits, and you actually would be talking back and forth and kind of giving you some tips and strategies on how you can deal with your debt collection lawsuit. So watch for that. That's going to be coming in the near future. It will be a paid thing. I try to keep the cost low on those. I know that that's the last thing you need is a bunch of additional costs to go with what you're dealing with. But I'll be launching that soon, and then you can participate on a more substantive level than here, like we do on YouTube or in the videos that I have. So, all right, let's jump in. Darlene saying hello from Golden Valley. Darlene, thank you for checking in each week. Also, we have Al. Thank you. I appreciate you supporting the channel. And people do this with the channel. This is something I wasn't even aware of until I launched YouTube, but people financially can contribute to the channel. It obviously takes some costs and expenses to do this. And so I appreciate you doing that. And we have AZ Med Girl throwing in some $10 there. Thank you for that. I appreciate that sincerely. So, all right, let's jump into some of the questions. Joe put his question up first. Relating to, he said he lost my trial because the subpoenaed custodian of records used your questions and had him adjusting his tie, but I tried to exclude his testimony because I had no proof he was authority to testify. The judge said no. Okay, so I take it that you subpoenaed the custodian of records, you used my questions, probably the cross-examination questions that I recommend, had him adjusting his tie, got him squirming there. You tried to exclude his testimony because I had no proof that he was the authority. I can tell you what you're dealing with there is just a ruling from the judge that gets frustrating. And particularly depending on the kind of court you're in, the backgrounds of the judges, it can be difficult if the judge gives you a ruling that you don't agree with. The nice thing is if you make the objections and the court overrules you, or you're asking the court to exclude the testimony, those are the things that appeals are made of. If you preserve those evidentiary objections, then if you go to appeal the case, those are the kinds of things that the Court of Appeals will look at. So sorry to hear that didn't turn out well, but I mean, you're taking the right steps, and it may set you up in a position where you can try to settle the case at a later date because they know that those issues, are ripe for appeal. So, all right, let's see here. MG Morgan says, hi, John. Morgan in Casa Grande. Hello, Casa Grande. Thank you for being here. What is the best way to stop collection calls? They aren't even my debts. Previous person with the cell number. Those Those can be very good. So to stop the collection calls, particularly if you've told them to stop calling, there may be a violation of what's called the TCPA, which is a federal statute that governs electronic communication. If you're getting a lot of collection calls and you're trying to get them to stop, and they're not even debts that you're related to or people or companies you're related to, give my office a call, MG, and let's talk about that, because that may be something we can help you with. Not only stop the calls, but maybe get compensation for even having to deal with the whole thing altogether. All right, let's see here. Benny says, I just went through a hearing, requested a dismissal to compel for arbitration. The judge allowed for the arbitration, but not the dismissal. And this will happen at times where the judge, this happens to me as well. We'll file a motion to dismiss and compel private arbitration, and the judge will kind of do a hybrid. The judge will say, well, I'm not going to dismiss, but I'm going to give you 90 days to initiate arbitration. So this is, and that's a win. I mean, that, you know, it's not as good as a dismissal, obviously, but it's still a win. But what you want to look at is that arbitration clause really closely, the terms and conditions. Sometimes it will say who's the party that needs to initiate the arbitration. And here's the language that I usually see in those arbitration clauses. It says that the party who has a claim against the other party is to initiate the private arbitration. So they're the ones that should file the first documents. So it's a situation, I mean, you know, they're suing you. You're not alleging any claims against them. So if the court says, okay, we're going to stop this so the parties can pursue private arbitration, I take the position that it's still the creditor that needs to file the documents with AAA or JAMS or those other private arbitration companies. And then if they don't, which often they won't because of the reasons we've talked about before, that it can be super expensive for them to do that, then if you go back in 90 days, I would renew the motion to dismiss at that point. I would say, hey, judge, I tried to do what you said. Here's the arbitration clause. It says they need to initiate it. They didn't do it. Now we just want you to dismiss the case. And I think that could be a pretty good strategy. So, all right. Let's see you at Noob back on the channel. Appreciate it. Filed for arbitration, and the courts gave the plaintiff 2 weeks to respond. Mediation is scheduled 2 days before the response date. Will mediation usually proceed while the motion is pending? Here's what I would do. I would file a motion to continue the mediation. Mediation is really where you're just trying to work out some type of settlement agreement between the parties. If there's a motion pending before the court that is dispositive, meaning it's going to deal with the case, it's going to force the case into arbitration, it's really nice to have a ruling on that before you go into mediation. And if you filed your motion to compel arbitration and they have 2 weeks to respond, you actually have a reply brief that you can file after they file their response. And then in most jurisdictions, the courts have up to like 45 days to issue a ruling. So it could be something where you're not going to get a ruling for a while. And so you can file a motion to continue the arbitration, just saying, hey, and you may even want to ask the other party, hey, will you stipulate? Will you agree to this? Let's push this out 60 days while we get this motion to dismiss dealt with. And then in the event that it's not granted, you'll go to arbitration at that point. So that's what I would do right there. So, all right, let's see here. Benny, coming back to your question with arbitration, this is what I'm saying. So the court's saying, okay, we're not going to dismiss your case and compel private arbitration, but we're going to stay the case. We're just going to put everything on hold, give you 60 days to begin arbitration, and then come back. You need to look at the terms and conditions of the arbitration agreement. You could initiate arbitration. Like I said, there's going to be a filing fee. I think both with AAA and with JAMS for the consumer, it's like $170 to $200 you're going to have to pay. But then they're going to have to be the ones who file a response, and there's a big fee. The awkward, quirky part of that is, unless you have claims against them, I mean, what is your claim? Because when you file for arbitration, you have to file a complaint saying you have allegations against the other party. They're the ones suing you. And so in most arbitration clauses, it's going to say they're going to have to be the ones to initiate it. So and that's why I'm saying, if you do that, I would send something in writing to the attorneys for the creditor saying, hey, the court said to initiate it. You're the one with the claims. Go ahead and initiate it. And then if they don't do it within 60 days, I would go back in and file the motion to um, what do you call it? Go ahead and ask for a dismissal at that point. So that's how I would handle it. And then you said also the creditor stated I would pay all the fees. Yes, typically not true that they're going to be able to transfer those over to you. If they were to go to arbitration and win, it may be something where they could get some type of fees, like attorney's fees against you, but the costs generally are not going to be imposed against you. So, all right. Well, I hope that was helpful. There's no other questions up there now. I think I hit all of them tonight. If there are additional questions, you got a couple more minutes before I'm going to close this out. We can go as long or as short as you want. Doesn't matter to me. But I'd appreciate any other feedback or any of those who may be interested in that boot camp that I'm planning on doing. It's going to take me a little while to get that framework of that put together. It's kind of a big undertaking for me. But you can go over to the YouTube channel and check out the community section, and there's a poll there, which I'd appreciate. Dave, thanks for checking in, and thanks for the support of the channel, as always. So, any of those, by the way, that haven't subscribed, I just passed 21,000 subscribers on the channel, which has been crazy to me because I started out with like 2,500. Please go over and subscribe. I appreciate that. You'll be notified when I put out new videos. All right, couple more questions here with YouTube user. My motion to compel arbitration was granted. Plaintiff refused to pay the fee. Case was closed. I moved to dismiss. Plaintiff in contempt of the order. Plaintiff claimed they didn't know the fee was $1,500. That's my response to the plaintiff. I don't care. I don't care what you knew or didn't know, or you did what was right. You did the right thing. I'm trying to come off that way. My response is I think you did the exact right thing. Goes on to say, and they said that was unfair. I replied, Judge still denied the motion to dismiss and also thought that the arbitration filing fee was too high and that it was cheaper to go through mediation, and then ordered a third mediation. The first two were unsuccessful. Not sure what happens next other than the plaintiff filing for summary judgment and getting a judgment. So, here's this is my deep sighs are frustrations with the court process. The creditor, this is their agreement. They drafted it. And if it's a debt buyer, they stepped into the shoes of that creditor. They get the benefits of purchasing the debt, and they get all the downside to it too. The downside may be that stupid arbitration clause that they put in there or their predecessor put in there. And so the court should hold them to it. It's not up to the judge to say if the filing fees from JAMS is too high. And so that's frustrating. To me, that's an appealable decision. If the judge does not dismiss after they gave them an opportunity to pursue arbitration and they don't do it, that's something I would appeal. That's really frustrating to me when the courts ignore all of those, the actual contract that the creditor has, that they don't hold them to their own contract. So, all right, let's see here. All right, we got someone from Provo, Utah, and Kelly, thank you for checking in. My wife and my daughter up there right now at a dance convention. If you put your daughters in dance, anyways, I won't start on my dance rants. It's really good for them. It's just crazy, time intensive and expensive. All right, Dave. All right, you're up at Yellowstone. How sweet is that? It is snowing. Wow. My last weekend, the reason why I was gone, I have two daughters. They're twins, and they're getting ready to graduate from high school. And I took them to Washington, D.C. One of my daughters is getting ready to join the Space Force, of all things. She's going to enlist in the Space Force this summer. So we took him out to D.C. so she could see what that is all about. A few more questions popped up. It says, if the debt collector doesn't have proof that I had the debt with the original creditor, should I agree with the summons that I had the debt with the original creditor? This is a good question. So when you're filing an answer, when you're answering the lawsuit, the overriding thing you need to remember, you need to be truthful. You need to be honest with what it is that your answers are to their allegations. You also, and this is kind of where the thinking like a lawyer comes into play, you need to read the answers or the allegations in the complaint very literally. If there's something in there that you're not sure, if they say you owe $5,629.32 and you don't have a clue how they came up with that number specifically, you can either deny it or you can state that you lack sufficient information and therefore you deny. And so, in a question like this, often with the complaint, they don't provide all their proof about the original creditor. If they're saying that the original creditor was Wells Fargo and you did have a Wells Fargo account, but if they don't put the account number, the last four digits of the account number, or they're just being very generic about it, I think it's appropriate to say that you lack sufficient information and therefore you deny. And then if that changes, you could always amend at a later point. But if it says, hey, the original creditor was Bank of America, the last four digits were 1234. John Skiba had this account and he opened it up on January 15th of 1996 or whatever, and all that's true, then I need to admit it. I can tell you when it comes to junk debt buyer lawsuits, the admitting that you owe money to the original creditor, who cares? The original creditor is not suing you, and so I don't have any problem with that. So, all right, let's see what we have here. Hi, John. Thanks for all you do. Thank you. It says, I'm a pro se plaintiff in an FDCPA case. I have evidence that the defense omitted a parent company from the corporate disclosure. How would you dispute this? Trying to think of how that came up. So it says you have evidence that the defense omitted a parent company from the corporate disclosure. How would you dispute this? I can tell you this. Anytime there's a dispute like this initially, it's best to bring it up to the opposing side and give them an opportunity to remedy it. Because if there's a failure to disclose, no matter what it is, or even you see this with discovery, if written discovery is sent over and they don't respond timely, the courts don't really want to hear from it until they hear that you've made some effort to resolve the issue. So, and then if they don't do it, it gives you all the more power to come in and you can use something like that to beat them, over the head kind of thing. So, let's see what we have here. AZ Medgirl says, can I use a credit report that reported on-time payments during and past the time the junk debt buyer states they bought the debt? Absolutely. Particularly, you need to, and you should use this if they file something like a motion for summary judgment. Because if you're trying to say, hey, if they're saying, hey, I bought this debt, and you're showing on your credit report that the original creditor is still reporting things showing your payments, that's absolutely a basis for denying summary judgment. It's even a basis for probably even getting the case thrown out or taking it to trial. So I would absolutely do that. So, all right. Let me see a couple other things here. Says, what happened if you lose your job in a Chapter 13 bankruptcy? Another Arizona person. Thank you. So Chapter 13 bankruptcy is different than Chapter 7 bankruptcy. One of the conditions of you being in a Chapter 13 bankruptcy is you have to have regular income. Doesn't really matter where it comes from, but there's got to be income coming in because you've got to make a planned payment to your creditors sometime over a 36 to 60 month period. And so if you lose your job, it really depends on if you think it's going to be permanent or if it's something where you think, you can get another job a couple months down the road. Like I recently had a client in a Chapter 13. She lost her job. She got one again like 45 days later. And so we were able to file a request for a moratorium on the plan payments, explaining they had lost their job. There's no income during that time period. And then as soon as she got a job, I filed an amended plan to disclose it, what's called Schedule I, to show the new income coming in. So you can, but if it's something where you're like, hey, this is going to be, or you've been out looking, you can't find another job, or your income goes down significantly with the new job, it may be possible to convert your case to a Chapter 7 and just finish the case out that way. So if you're in a Chapter 13, you have an attorney, which a lot of people do, highly recommend that you talk to them about that. Because that can be kind of a tricky thing to navigate, but you can still save the 13 as long as you can replace the income that you were making. It's when you can't replace that income that it becomes pretty difficult. So, hey, Darlene, thank you for supporting the channel. I really appreciate that. So, all right, let's see here. I don't know if we've got a couple others. We'll try this last one of Crimson Tide here. Have a suit. Plaintiff is listed as Unifund, Capital One. Capital One is not the owner. They sold it. Was this filed correctly, or does it not matter who they listed as the actual plaintiff? Yeah, I mean, all those things matter. If the original creditor is not correct, or sometimes what I'll see is in the complaint, they'll allege that, Capital One sold it to Unifund when there was like 3 other sellers in between. All those things matter when it comes to establishing an unbroken chain of title, because that's what they have to have. They have to be able to say, okay, Capital One had the credit card, and then it went from here to here to here to here to here, and then to us at Unifund. And unless they can show that with proper evidence, with proper authentication by a witness, then they're going to run into problems. So, all right. Kelly, I can't answer yours. Let me go back and see what Kelly's are. Kelly says she was served on Monday, served Monday for a debt on April 4th, 2014. So an old debt, medical bill. Is this outside the statute? And the statute on written contracts in Utah is 6 years. So the statute of limitations usually begins to run at the time the account goes into default. And so I usually look at that under most agreements, like if it's a credit card agreement or like this was a medical bill. The question is, when did it go into default? And, with the credit card, I always argue it's 30 days after the account goes unpaid, because at that point, it's then, they could actually sue you for it, even though it's 30 days past due. Now, excuse me, if you bring it current at some point, then that resets the statute of limitations. But in a situation like the medical bill, it may be a little bit different because it's not a revolving line of credit. You'd have to look and kind of see what the terms and conditions are with the doctor. They may be counting it at the time of charge off. Now, charge off is usually 6 months after the bill is first assessed to you. If you don't pay it, then, the statute may start running there. So you would need to look and see when the statute starts running, whether it's, 30 days after they send it to you, or whether it's that 6-month period, count out the 6 years. And if the statute has run, then what you can do, instead of an answer, you can file a motion to dismiss, alleging that the statute of limitations has run and they cannot collect on the debt. If you're successful, then the case will be done. If you are not successful, the court will give you time to file a written answer to that. So let's see here. Adriana says, will you do a video on how to submit a case to JAMS for arbitration? I use your tutorial, file my motion for arbitration. Hello from Memphis. Love Memphis. When I was in college, I played in the Liberty Bowl in Memphis, Tennessee. I played football for BYU. I believe we played Marshall there, and we played in January, and it was freezing. That's what I remember. It was I grew up in Utah, where it's all this kind of snow, but for some reason in Memphis, it was freezing. I remember that game was one of the coldest games I've been in. So, yes, I can do a video. I can make note of that. I'm always looking for different material to do video on, so I can absolutely do one on how you'd actually submit that for arbitration. Again, I would recommend you go look at, the contract with the payday loan, terms and conditions, and see who's the one who's supposed to be submitting it, because that's the tricky thing is you likely don't have a claim against the other party. You're not suing them for anything. They're suing you. And so if you were to file a claim, arbitration is really just it's like a privately held courthouse, you're just filing your lawsuit. Well, if you're filing a lawsuit, what are you alleging against them? So that's why it makes more sense for them to do it. But yeah, that is something absolutely I could do. So, all right. Kelly, go back to your question with statute of limitations. If it says 30 days, my opinion, I talked to a Utah lawyer, but my opinion is that once that has expired, that's when the statute starts to run. So you may have a good argument there. So, all right, let's see a couple more here. Monica says, Chase sued me for a credit card debt. Judge granted motion to compel, but no dismissal. Do I need to file arbitration? Clearly, I need to do a video on this. There's a lot of this what's going on. It's good to hear that the judge is at least, pushing the case out the door, but I can do a video. I'll do that next week. I'll do a video on what your next steps need to be in the event that the court grants the motion to compel, but they don't dismiss, what you need to do next. So, all right, let's see here. Let's do Manny. He says, once my Chapter 13 case is dismissed, how soon can I expect creditor to reach the debtor? What are the actions taken, and what are the other best options? So if a Chapter 13 case gets dismissed, it's as if you never filed bankruptcy. Your creditors will get notified electronically and through the mail, usually within 3 to 5 days after it's dismissed. And then at that point, they can start collections again. And so particularly if you have car loans, things like that are behind, you need to be careful because they could end up going in and trying to repossess. So that's the one thing I tell people anytime their Chapter 13s are dismissed, watch out for the car loans, because that could be a big issue. All right, last question. We'll finish up with the YouTube user here regarding your question about a judge who agrees with the plaintiff that the arbitration fee is too high, denied my motion to dismiss. How would you handle the next mediation? What advice doing before any judgment is entered? Mediation, I would look to see, is there some middle ground that, or an amount. I always say go into mediation knowing what your budget is to settle this, and don't agree to anything that doesn't make sense. But if it's something, something you can do is say, look, you have an appealable issue here with the judge, especially interjecting that the arbitration fee is too high. None of the judge's business, how much that is. I mean, truthfully, it's not. So those are appealable issues. That could give you some leverage and some motivation to get that doing. It's true, if mediation doesn't work, likely their next step is to file a motion for summary judgment. And that can be kind of tricky. And so I would, but even if judgment gets entered, you still have the appealable issue of whether the judge should be, giving the opinion on whether the arbitration fees are too high. So, all right, we'll wrap that up. Hey, Alex, sneaking in right there. I was going to leave and you made it. All right, we'll do Alex. This is just for you, Alex. Motion for summary judgment versus judgment on the pleadings, how to respond to each. And of course, there's always a shout out to Yuma. This is going to be all right. We'll dive in. Motion for summary judgment versus motion for a judgment on the pleadings. The motion for summary judgment is very common in debt collection cases. Motion for summary judgment, the idea behind it is the creditor is essentially telling the judge, hey, judge, we don't need a trial. Just look at all of our evidence and tell us if we win. And the judge is only supposed to grant a motion for summary judgment if basically there are no factual disputes. Basically, if the parties agree on all the facts and they're basically saying, hey, judge, we agree on everything. Just look at this and tell us who wins. Apply the law to it. That's what a motion for summary judgment is. Motion for judgment on the pleadings, if let's say that they file a lawsuit against you and you file an answer, and let's say that you admit everything in their complaint. If you admit everything in their complaint, then you're likely next going to get hit with a motion for judgment on the pleadings, because they're going to say, look, there's no dispute here. They agree with everything, just grant judgment. So that's when you're going to see a motion for judgment on the pleadings, when there's really no dispute in the documents that have been filed as far as their allegations and then your response to it. If there's no dispute, I mean, that courts are only there to resolve disputes. And if you agree to everything that they're saying, then the court's going to go ahead and enter a judgment against you on that one. So, V, I'm going to help you out since it's your first time catching us live from California. Calvary Portfolio sued for $3,844, attempted to serve me twice, but was unsuccessful. I only found out then because I looked your name up in the court. And I can tell you this is how a lot of people find out that they've been sued. And here's kind of the danger area that this kind of presents is my advice. I won't say advice. My opinion on things is it's better to just accept service. Some people will dodge the process server and say, you know what, if they don't ever serve me, then I can't move forward with the lawsuit. Usually what happens is they will come in and go ask the court for permission to be able to serve you through what's called alternative service. Maybe they'll get permission to just tape it to your door, send it to you in the mail, or in the old days here, they used to allow them to put it in the classified sections of a newspaper. And so the problem with that is if they do alternative service, so often people don't see it. They in the classified section, no one ever saw it. Sometimes they tape it to the door, and wind comes through, blows it off. They put it in the mail, and you don't get, a lot of people don't check their mail regularly, and you end up with the default judgment. There are defenses to these cases. And so to me, the best thing is to deal with it head on. Now, your follow-up question here is that they've already given you a court date. In some jurisdictions, when they file the complaint, they actually give them a court date right then and there. I would file a response. Wow, they set the 2-2, so they're already at a year almost. I would still go ahead and file a response to it. It's better to deal with it head on and get it dealt with that way than run the risk of default. Because if they end up with the default, they not only get what they're asking, they can add attorney's fees, court costs, and it just can make a giant mess. So, all right. Well, hey, everybody, thanks for listening in today. Appreciate all the questions and the opportunity to talk to all of you. I'll make sure we're back here on Thursday night. I'm going to be working on that video about what you do once the judge grants your motion to compel arbitration, what the next steps are from there. And I will catch you next week.